Your Honor.
Yes.
Okay. Mr. Schmidt is ready on the feed.
Go ahead and move Kim. All right, good afternoon, Mr. Schmidt. Who are you ready on?
Roy and Hamilton. Come on down, Roy. Yeah.
All right, this is cause number CR 21-71, State of Texas versus Roy Hamilton. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, I was recently appointed on Mr. Hamilton's motion. I've met with him and I've had some conferences with the state, but I have not received all the communications I need or asked for a reset on his motion.
Objections from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Hamilton for motion to revoke on Thursday, July 3rd. (1:30). Next,
This is Brandon Krill.
cause numbers 2025-92, 2025-98, CR 23-158, CR 24-206, State of Texas versus Brandon Ashley Krill were set on pre-trials and the motion to revoke. Go ahead.
That's correct, Judge. At this point, as far as the pretrials are concerned, I have discussed with Mr. Hartwell after review and Mr. Krill's history pertaining to mental health. I intend to file some motions seeking some additional evaluations and potentially asserting a defense. So at this point, we're going to ask for a reset so that I can have an opportunity to file those motions and get him evaluated.
Any objections from the state?
None from the state, Your Honor. Thank you.
All right, we'll keep him on the evidentiary docket for July 3rd. All cases.
Sure.
Who's next?
You should have a plea for Michael Whitten in your queue.
All right, go ahead and bring Mr. Whitten up. This is cause number CR 24-00009, State of Texas versus Michael Joseph Whitten. Mr. Whitten, sir, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. All right, your name is Michael Joseph Whitten, is that correct?
Yes.
All right, Mr. Whitten, it appears that you were before the court on May 29th of last year. You pled guilty to the first-degree felony offense of aggravated assault with a deadly weapon. Court heard the evidence and followed a plea agreement that day. The court deferred a finding of guilt and placed you on 6 years of community supervision and assessed a $2,000 fine. I see that the state has filed a motion to adjudicate your guilt and revoke your community supervision. They filed that, it looks like in November of last year. And in that, they have alleged what appears to be 5 separate allegations of violations. Have you had enough time to review those allegations of violations with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes.
Do you have any questions about your plea agreement today that you intend to enter?
No, Your Honor.
And it appears that that plea agreement is upon your plea of true to those violations and allegations of violations. The state is recommending that the court adjudicate your guilt, revoke your community supervision, and assess punishment at 10 years confinement in the Texas Department of Criminal Justice, and ordering you to pay the balance of your financial obligations, which is your fine, court costs, and reimbursement fees. Mr. Schmidt, what would the credit time that Mr. Whitten would be entitled to?
Judge, I'll pull it up. I believe it's 364 days, but let me give you the specific. 338 days, Judge.
338?
Yes, sir.
All right, so Mr. Whitten, you would receive 338 days credit towards your sentence for the time that you've already spent in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent to enter into this agreement? Is he doing so intentionally, knowingly, and voluntarily? And does he intend to waive the formal reading of the motion and plead true to all counts?
Judge, we intend to waive formal reading, plead true to all counts. I do believe he is mentally competent and he's entering his plea knowingly and voluntarily.
Thank you, Mr. Schmidt. All right, Mr. Whitten, then at this time, I would ask you, how do you plead to the counts alleged in the state's motion to adjudicate counts 1, 2, 3, 4, and 5? Are those counts true or not true, sir?
True.
And you're pleading true to all counts because, in fact, the allegations are true. Is that correct?
Yes.
And Mr. Whitten, has anyone threatened you, forced you, or pressured you to plead true to any count?
No.
All right, the court will accept the defendant's plea of true to each count. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights of plea of true?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, based on the evidence before the court finds that the defendant has violated the terms and conditions of his community supervision. The court finds all 5 counts to be true. The court will follow the plea agreement and recommendation in this case. The court hereby convicts the defendant of aggravated assault with a deadly weapon, makes an affirmative finding that the deadly weapon is a firearm. Court hereby, upon adjudicating the guilt, revokes the defendant's community supervision, assesses punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders him to pay the balance of his financial obligations. Court also awards the defendant 338 days credit towards the sentence for the time that he has spent in jail on this cause. Was there perhaps an error in the motion to revoke? I think it indicated that it was a first-degree felony, but I believe that the judgments indicating that's a second-degree felony.
I believe it was a second-degree felony.
Second-degree felony. Okay. All right, Mr. Whitten, you're hereby remanded to the custody of the Sheriff's Department so they can carry out the terms and conditions of the sentence. Mr. Whitten, when you do get out of prison, if you've not already satisfied all of your court costs, fines, and fees, upon getting out, those are not discharged. You'll have to report to the courthouse and make payment arrangements to get those discharged. Otherwise, a warrant could issue for your arrest. Okay.
Yes, sir.
All right. Thanks, sir. If you'll step over with the bailiff to be.
Just stand like that. Thank you.
I'm here. I'm here. So, so is there any way
So that's what it is. You know, that's probably July 1st. Okay.
Mr. Schmidt, who are you ready on now?
Judge, this is Keith Pryor.
All right, is Mr. Pryor, tested hearing today?
No, sir, we intend to, open plea before the court. At which time we would ask that the court order a PSI and set the matter for sentencing on your July 3rd docket. There is no plea agreement, in this case. I believe that after discussions with Mr. Hartwell, they intend to abandon 2 counts on their motion to adjudicate. I don't have that motion in front of me, but it's the 2 pertaining to financials. And then Mr. Pryor intends to plead true before the court on the remaining counts.
And you said you want to do that on July 3rd?
Yes, sir.
Any objections from the state?
No objection from the state, Your Honor. And that is correct. Sorry, Your Honor, I'm having some computer troubles of my own. There are 2 counts that allege failing to pay. It's come to the state's attention that Mr. Pryor has paid off those financial obligations, so the state would be abandoning those 2 counts.
Okay, all right, court will set Mr. Whitten then for hearing on July 3rd at 1:30. I'm sorry, what did I say? Yeah, I said Mr. Whitten. Mr. Pryor for hearing on July 3rd at 1:30.
And Judge, just for clarification's sake, do you intend to order that PSI now for its availability prior to the July 3rd sentencing? Or in other words, it can be bifurcated with the adjudications on deferred, so we intend to exercise his right to a sentencing hearing on the motion with a plea of truth to the actual allegations. But I mean, just from a logistics perspective, what does the court intend?
I intend to request the probation department to conduct the PSI prior to the hearing and then make it available to counsel.
Thank you, Judge. That's what I was at. Appreciate it.
And Ms. Burns, are you there in the courtroom?
Yes, sir.
Can you consider this my official request for Mr. Pryor, Keith Pryor, and cause number CR 15322 to be given a pre-sentence investigation?
Yes, sir.
All right, thank you.
And I'm waiting on a couple of sets of papers. Mr. Manning is going through some documents as well, so it'll be a couple of minutes, Judge.
Okay, all right, or we'll stand in recess until you're ready.
I'm ready, Your Honor.
I'm sorry, I can't hear you.
I have a few things.
All right, give me just 1 second. I need to sign Mr. Whitten's papers before I get too far away. All right, Ms. Tabram.
Okay, we should have,
Mr. Adams?
yes,
Yes, Mr. Adams is present on Zoom. Are we ready for Mr. Baker?
yes, Your Honor.
All right. Hartwell, we'll make sure your microphone is on. All right, this is cause number CR 21-350, State of Texas versus Leon Thomas Baker. We're set for status today. Mr. Adams, any announcements?
So yes, Your Honor, it's been a minute since we were last before the court. I've reviewed the file. There were some unfinished plea discussions between myself and Mr. Hartwell going back to about this time last year. I need to follow up with Mr. Hartwell about that. Mr. Baker has been with the Van Zandt County Jail now for a little over a month. I haven't seen him or visited with him since then. I had two jury trials back to back at the end of April, beginning of May, and I need to get over there. I've blocked off some time to go do that this coming Tuesday of this coming week. Other than that, I need to, well, in summary, I need to find out what we can accomplish, if anything, with the district attorney's office, and find out from Mr. Baker whether to what extent, or whether his position on what's acceptable has changed. And from there, we'll know what we're going to do insofar as trying this case or resolving it with an agreed settlement.
What I could do, Mr. Adams, is I could reset him for a contested hearing on July 3rd, or y'all could enter into an agreement that day.
Yes, I guess I need to know, Mr. Baker's being held on a $150,000 surety bond. Okay. Is that the earliest that the court could entertain us?
That is the earliest evidentiary docket that I have. I do not have one in June.
Okay.
At this time.
All right. We'll
Your
go.
Honor, if it makes a difference, I believe this one is the case in chief, so that it's not an MTA or MTR or anything. I believe if memory serves, we had come to an agreement, but Mr. Baker failed to appear, and I don't know if he was detained elsewhere or if something else happened.
Oh, I see. So this is not an evidentiary. This is not a motion to revoke.
Correct, Your Honor.
Right. That's correct, Your Honor.
Okay, so yes, I could get you in there earlier. Let's see, I've got settings on June 10th, June 12th. Those are my next two, 10th and 12th.
Yes, sir. I am free and clear on the 12th, so I'd opt for that one, I think.
Okay, thank you, Mr. Harwell.
Yes, sir.
All right, then the court will set Mr. Baker then for, I'm gonna call it docket call. We're gonna set that June 12th at 1:30.
Yes, sir. And Chris, I'll be in touch with you here in the next few days.
Sounds good. Thank you.
All right. And Mr. Baker, I'll see you Tuesday.
Okay, thank you, sir. Thanks, Your Honor.
Thank you, Mr. Adams. Good to see you.
So,
Thank you, Your Honor. Good to see you.
that's very nice.
Now, he'll see you on Tuesday. I'll let him talk because this is on YouTube.
Hey, Ram, do you have anything else?
Yes, Mr. Shoemaker.
All right, cause number CR 23-74, State of Texas versus Christopher Reagan Shoemaker.
Your Honor, he states that he's going to retain an attorney.
Is that right, Mr. Shoemaker? You want to hire an attorney to represent you?
Yes, sir.
Do you know how long it would take you to do that?
Not entirely sure, sir. I gotta make some phone calls, make some communications, but try my.
All right, so this is a motion to revoke or adjudicate, I believe, since it was unsuccessful discharge for safety. All right, so what I'll do is I can set this July 3rd, Mr. Shoemaker.
Yes,
and
sir.
give you a little over a month to try to get squared away, okay?
Appreciate you, sir. Sir, I have a question for you if you don't mind.
I can answer it if it's a procedural question, but if it's anything about bond or something like that, we won't be able to entertain it.
It has to do with retaining a lawyer, sir.
Yes, sir, go ahead. I'll try this.
So in the event, my goal is to retain him. If I can't, can I still apply for a court appointed?
You can always apply for a court-appointed attorney, and that's always going to hinge on whether or not you are deemed indigent, which is going to be determined after the court reviews your financial status, which includes any assets that you own, money that you have against liabilities and debts, things of that nature. So you can always apply, but the court always has to conduct a review to determine if you meet that standard. But I think the answer to your question is yes.
Yes, sir. Thank you.
You are.
Is that all? Thank you.
All right, what about Amber Harris?
She's not in here yet. I was trying to look at something else. If you can. He's gonna go get her. And then on Mr. King, Keith King. He has completed his affidavit of indigency this afternoon.
Okay, I see. I still had Jonathan listed on that case. So
Well,
Jonathan,
this is a motion to revoke.
Okay.
But he will,
is he gonna be deemed indigent?
yes, sir.
All right, and
And so I was going to appoint Mr. Manning.
okay,
So do you want Mr. Manning to reset?
yes, we can reset Mr. King then for July 3rd. And if they reach some kind of an agreement beforehand and they need it heard, then we can set it either June 10th or 12th.
July 3rd. He's going to appoint Mr. Manning, which we had previously, and then y'all have something like that before July 3rd. No. Right, Your Honor, let me talk to Miss Harris, and then I'll tell you when we're ready.
Actually, I think.
Oh, I think Mr. Manning's ready.
I think it's going over right now.
I'm probably not on the ball. I'm a delegate.
Judge, I am not able to hear you. Yes, Judge.
Who are you ready on?
Judge, ready on the pleas for Mr. Phillips and Mr. Johnson.
All right, bring Mr. Johnson up. This is cause number CR 25-46, State of Texas versus Zion Dwayne Johnson. Mr. Johnson, sir, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. Just one moment while your paperwork's pulling up. All right, Mr. Johnson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
No. In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir. Yes, sir. Sorry.
Yeah. Do you have any questions of Mr. Manning or the court before you go further?
No, sir.
Is there anything about the paperwork that you've read and signed today in your plea agreement that you don't understand?
No, sir.
Okay. Mr. Manning, do you believe Mr. Johnson to be competent?
I do, Judge.
You've explained to him his rights as they regard to this case.
I have.
Do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
Mr. Johnson, I see that you are charged by indictment with a third-degree felony offense of continuous violence against the family. The third-degree felony does have a range of punishment of not less than 2 years in prison up to a maximum 10 years in prison and a possible fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court consider the evidence, assess your punishment at 10 years confinement in prison, along with a $2,000 fine plus court costs and reimbursement fees. Mr. Manning, how much credit time would Mr. Johnson receive towards his sentence today?
Judge, we calculated it with the DA's office, and that time is going to include 135 days.
Mr. Johnson, you would receive 135 days credit toward your sentence. Is that your understanding of the plea agreement today?
Oh, yes, sir. Yes, sir.
All right, so at this time, Mr. Johnson, I've explained to you what you're charged with. I've explained to you what the plea agreement is and what your range of punishment is. How do you plead to continuous violence against the family? Mr. Manning, is there a question?
And Judge, if I may, just there's one other term of the plea agreement that didn't make its way into our paperwork, but there is a additional juvenile suit, 2 juvenile suits. They're going to be non-suited as a part of this plea agreement. I believe, if my understanding, the state has those orders of non-suit in hand for today's hearing. But that is part of and an integral material part of this plea agreement.
That's correct, Your Honor. I have a motion and order non-suit in hand that I can deliver to the county court at law as soon as possible.
Okay. Court understands that y'all made that as part of your agreement. It's not going to be reflected in the record of this court, not in the clerk's record, but it will be on the reporter's record. And so I've noted that.
Thank you, Judge. And with that, we're ready to continue.
All right, Mr. Johnson, then how do you plead to continuous violence against the family?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further from the state, Your Honor.
Anything further from the defense?
Rest and close, Judge.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement today. The court hereby convicts Zion Dwayne Johnson of continuous violence against the family, a 3rd-degree felony, assesses punishment at 10 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court costs, and $20 in reimbursement fees. The court awards the defendant 135 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Johnson, once you're released from prison, if you've not paid off your fines, court costs, and fees, you'll need to report to the courthouse to make arrangements to discharge those. Failure to do that could result in you being rearrested on the failure to pay court-ordered fees and fines. Mr. Johnson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with the bailiff to be fingerprinted.
Yes,
And
sir.
Your Honor,
Hang on, Mr. Johnson.
I apologize. Being a victim case, just for the court's information, state is in compliance. Victim impact statement was provided and not returned.
Thank you, Mr. Harwell. All right. Thank you, Mr. Johnson.
No, not Herschel Brand. No, she.
Right, Mr. Manning. Is this Mr. Phillips?
It is, Judge. Here and in person with Van Zandt County Jail.
Finally got him here.
Yes, sir.
And you were in Kaufman before, right?
Yes, sir.
And Mr. Manning, has everything been wrapped up in Kaufman?
No, Judge. They're still pending over there. I spoke to Mr. Phillips' attorney in that county as recently as just a while ago. I've been in communication regarding this plea and how it would affect their plea negotiations over there, and he is aware of the situation as we're proceeding today.
Thank you, Mr. Manning. All right, this is cause number CR 24-80, State of Texas versus William Howell Phillips III. Mr. Phillips, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thanks, sir. You can lower your hand. All right, Mr. Phillips, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Are you currently undergoing treatment or on medication for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on here today?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney and the work that he's done?
Yes, sir, I am.
Do you have any questions about any of the paperwork that you've read and signed today?
No, sir, I do not.
All right, thank you. Mr. Manning, do you believe Mr. Phillips to be competent? And if so, do you believe he's entering into this agreement intentionally, knowingly, and voluntarily?
Judge, he is competent, and after explaining to him the pros and cons of this deal, I do believe he's entering into it intentionally, knowingly, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Phillips, you are originally, let's see, you were charged with assault of a family or household member by impeding breath or circulation. I see that the plea agreement is upon you pleading guilty to that. The state's recommending that the court consider the evidence, convict you of the offense, sentencing you to 2 years confinement in prison, along with a $100 family violence fee, court costs of $290, and reimbursement fees of $120. Mr. Manning, what would be the total jail time credit for Mr. Phillips?
Judge, we believe that to be calculated at 349 days credit time.
Okay, so Mr. Phillips, you would receive that as your back time for time that you've already spent in jail on this case. Understanding the range of punishment is not less than 2 years up to a maximum of 10 years and a fine not to exceed $10,000. So I see that the recommendation is a lawful sentence. Mr. Phillips, at this time, I would ask you, how do you plead to assault of a family or household member by impeding breath or circulation, a third-degree felony?
I plead guilty, Your Honor.
And Mr. Phillips, are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Phillips, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
The stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I believe there is a BIS on file that should have been forwarded to the court.
All right, court does have that. Court will review the victim impact statement at this time. Mr. Hartwell, there was I'm not sure if it's a restitution request, but there was a monetary amount placed in the victim impact statement. Has that been addressed by your office?
Your Honor, state was unable to get supporting documentation to order that in the as restitution as part of the judgment.
And I don't believe that I have the tracking form that goes along with this.
I'll print one off.
Okay.
Thank you, sir.
All right, court has reviewed the victim impact statement provided by the victim in this case. All right, anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement. Court hereby convicts the defendant of assault of a family or household member by impeding breath or circulation, a third-degree felony. Court, pursuant to the plea agreement, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice. Orders the defendant to pay a $100 fine, $290 court cost, and $120 in reimbursement fees. Court awards the defendant 349 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Phillips, once you're released from prison, if you've not discharged your fines, court costs, and reimbursement fees, you can report to the Van Zandt County Courthouse and make arrangements to do so. Failure to follow that order could result in the court issuing for your arrest, okay?
Yes, sir.
All right, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fair.
Yes, sir. Oh, God. 070. Oh, after this. Wait, the 157.
Mind if I approach? Yes, sir, please. Thanks, sir. Here, let me get this reference. Thanks, sir. Thank you. All right, Mr. Manning, who's next?
Judge, this is Mr. Munns. And
Munns?
if we may have a copy of the indictment to review.
Sure, give me just one.
Judge,
Yes, sir.
after reviewing the indictment, Mr. Munn's middle name is not spelled correctly. It is, he's informed me it's Chaes. Other than that, his name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty and requests to be set on pre-trial docket.
All right, is there any motion by the state?
Yes, Your Honor. State moves to amend and interlineate the indictment to reflect the proper spelling of the defendant's middle name.
Any objections, Mr. Manning?
No objection.
All right, then the court grants the state's oral motion to amend the indictment to correct the spelling of the middle name of the defendant. Court will order that the indictment reflect the middle name to be spelled Chaes. I will make that interlineation today. Further, the court finds that Mr. Munns, having waived the formal reading of the indictment, court does enter his plea of not guilty and not true to the enhancement paragraph in the indictment. The court will set this matter for pretrial hearing. Mr. Manning, you want July 10th?
That'd be fine, Judge.
Okay. Court sets Mr. Munns for pretrial hearing July 10th at 1:30.
Oh, and Judge, I'm sorry, there was one other matter Mr. Munns asked me to take up. I believe he's being held on some additional charges that have not been indicted. He requests a PR bond for those cases. If the state's in agreement, I can send over an agreed order this afternoon and have the judge sign off on that.
I'll leave that between you and the state. And then if y'all have an agreement, submit it. If y'all don't, then you'll have to follow the motion and set.
Yes, sir. Yes, Judge.
Who else do you like?
Judge, Mr. Tienda LaFlash.
All right, this is cause number CR 22-295, State of Texas versus Avery Llash-Tenda. And we're here on a motion to revoke. Go ahead.
Judge, prior to my leaving for vacation, I had provided some mitigation or exculpatory evidence regarding the allegations contained in the MTA. I haven't had an opportunity to follow up with the state on those. If we could have a one more setting on Mr. Tienda LaFlash's case, I believe we should be able to get something figured out.
And Your Honor, if I could have just a moment to look, I have been able to converse with probation. I just want to refresh my memory as to that conversation. Might be able to resolve this today. Yes, Your Honor, and I apologize. I had printed off a motion to withdraw the MTA. After discussing with probation, we were able to get in contact with Kaufman County. I can't remember exactly what Kaufman's position was. This is I believe a single count MTA for a new charge arising out of Kaufman County. But after discussing with Ms. Clark over at the probation office, probation was in agreement with withdrawing the MTA and reinstating Mr. LaFlash on probation. So I can work on reprinting that motion and getting it to the court today.
Did you hear all that, Mr. Manning?
I did, Judge, and my client's excited to hear that, and we'll wait that order being sent over.
Okay, when that's presented to the court, if probation's in agreement with it, then court will grant that.
Thank you, Judge.
Anyone else ready, Mr. Manning?
Judge, I believe the only other person I have is Miss Young. But I do need a couple of moments to speak to her, so I'll let Mr. Schmidt take over.
Yes, sir. Mr. Schmidt, who would you like?
Amber Harris.
Sure.
I'll meet you tomorrow. Come on down, Amber.
Right, this is cause number CR 23-161, State of Texas versus Amber Danielle Harris on the state's motion to revoke. The assuming that she's completed the request for court appointed counsel and you've been appointed, Mr. Schmidt, by your appearance here today. Go ahead, Mr. Schmidt.
Yeah, it's correct, Assumption Judge. I have been appointed by Ms. Taberham here a few minutes ago. Obviously, we're not ready. I have received a copy of the motion, but I need to reset to the July 3rd date.
All right. Court recess, Ms. Harris on the course next contested docket July 3rd at 1:30. Anyone else, Mr. Schmidt?
You should have Holmes and Martinez in your queue ready on those.
All right, let's go with Mr. Holmes.
First one, come over.
All right, Mr. Holmes, if you'll raise your right hand, this is cause number CR 24-55, State of Texas versus Gerald Alexander Holmes. Mr. Holmes, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Holmes, you were before this court on December 17th of 2024, in which you pled guilty to the second-degree felony offense of indecency with a child by sexual contact. The court heard the evidence that day, followed a plea agreement that you reached with the state, and the court placed you on 6 years of community supervision. It was during that period that the state filed a motion to revoke or a motion to adjudicate, and then amended that 2 times. The state's second amended motion being filed May 15th, 2025. In that motion, the state has alleged what appears to be 16 separate allegations of violations. Have you had enough time to review that with your attorney, Mr. Schmidt?
Yes, sir, I have.
And are you happy with Mr. Schmidt and the work that he's done for you as your attorney?
Yes, sir.
Do you have any questions about your plea paperwork that you signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Holmes to be competent to enter into an agreement? Does he waive the formal reading of the state's motion, and is he intending to plead true to all counts?
We do intend to waive reading. I do believe he is competent. The state has abandoned several counts in the state's motion, which is reflected in the judgment. I don't have those counts in front of me because once I hit submit, I can't look at it anymore. But I think it's correct on the judgment. But he does intend to plead true to all the other counts, not specifically excluded.
Okay. All right, for the record, it appears the state's agreeing to abandon counts 1, 13, and 14. Does that sound right, Mr. Schmidt?
Sounds right.
Okay. And do we know the credit time that Mr. Holmes would be entitled to?
Judge, at this point, based on Ms. Abney's calculations, one second. She stated 42 days. From my position here, I don't have any way to verify that. I know Mr. Holmes has been in custody or out of custody on multiple occasions throughout my representation. I know they're not all related to this cause number or this transaction. So at first blush, I can't dispute the credit amount, and there's no way for me to validate it. But at a minimum, he has 42 days credit.
Does Mr. Holmes believe he has more than that?
I think Mr. Holmes has the same analysis that I do. I don't recall, because he had been arrested on some charges prior to my representation, bonded out on those. The case that I'm dealing with, these cases, I think I was not initially appointed representative on that, but on a newer case, which subsequently got rejected, we got him bonded out pretty quick. So it looks correct to me. So I'm not disputing it. I'm not objecting to it. I'm just saying it may be incorrect. I know that's wishy-washy, but
Well,
it's best I can do.
Yeah, I want Mr. Holmes to be, I want him to get whatever credit that, he's entitled to. And I don't want him to go down to TDCJ and then us have to bring him back if there's a complaint about, credit time. I think there's also, perhaps a law that says that Mr. Holmes is not entitled to any back time credit if it's a state jail sentence. Is that correct?
That's correct, but this is not a state jail sentence.
It's not a state jail sentence.
No, sir, this is a TT sentence.
Okay, I see that. So, Mr. Hartwell, can you, or Mr. Hernandez, can either one of you weigh in on what days, Ms. Abney has calculated so that Mr. Holmes can be in a position to say he either agrees to it or doesn't agree to it?
Yes, Your Honor. I could have just a moment. There should be an email with the breakdown.
Let's go 42 hours. Is that what they're doing? I don't know.
Well, I think it's right. I mean, we don't have a dispute.
It's still won't go with that.
Yeah, Judge, I think we can agree that 42 days is probably accurate.
Is accurate?
Yes, sir.
All right. Mr. Holmes, you agree?
Yes, sir.
All right, and I see here, Mr. Holmes, that the remainder of your plea agreement is upon you pleading true to the counts that are not abandoned. The state's recommending that the court adjudicate you, convict you today of indecency with a child by sexual contact. And they're asking the court to revoke your community supervision and assess punishment at 8 years confinement in prison, with you also being ordered to pay the remaining balance on your fines, court costs, and fees. Mr. Holmes, is that your understanding of the plea agreement?
Yes, sir.
All right, then, Mr. Holmes, at this time, I would ask you, how do you plead to counts 2 through 12 and counts 2 through 12, 2 through 12, counts 15 and 16. Are those counts true or not true?
True.
And you're telling me that those are true because in fact the allegations are true, correct? And Mr. Holmes, have you been pressured, forced, or threatened to have to plead true to any of these counts?
No, sir.
All right, then the court will accept the defendant's pleas of true to those specific counts. Mr. Schmidt, any objection to the defendant's waiver of rights and plea of true being admitted?
No objection.
All right, that is admitted into evidence. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court does find that Gerald Alexander Holmes has violated the terms and conditions of his community supervision. The court finds those counts to be true, which have not been abandoned by the state in the judgment. The court on that finding follows the plea agreement. The court convicts Gerald Alexander Holmes of indecency with a child by sexual contact, adjudicates his guilt, revokes his community supervision, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders him to pay the balance of his financial obligations. Further, the court does award Mr. Holmes 42 days credit towards his sentence for the time that he has spent in jail on this cause. Court finds that Mr. Holmes has been prosecuted and convicted for a Chapter 62 offense that does require sex offender registration. Mr. Holmes been provided a copy of Chapter 62?
Yes, sir.
All right, thank you. And, okay. All right, so Mr. Holmes, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. If you've not resolved all of your fines, court costs, and fees when you're released from prison, it's important that you report to the courthouse and take care of that. Failure to do so could result in you being rearrested for failure to pay. All right. Please step over to the deputy to be fingerprinted.
Well, I say that now.
Schmidt, remind me, this is a lifetime registration on Mr. Holmes' sex offender admonishments, correct?
That is correct.
Filling that out as we speak. All right, who's next, Mr. Schmidt?
Mario Martinez.
Mario Martinez, CR 21-178. Go ahead, Mr. Schmidt.
Judge, this is a plea. It should be in your queue.
Don't have Mr. Martinez in the queue. Oh, I'm sorry. Here it is. I do have it, Mr. Schmidt. Went to a different inbox.
Okay. Rodriguez Martinez.
Now let me double check.
Yeah, we submit those just about 20 minutes ago.
Yeah, I do have it.
Okay.
All right. Mr. Martinez, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Is your name Mario Martinez?
Yes, Your Honor.
And Mr. Martinez, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
It appears that you were before this court on October 14th of 2021 on the offense of tampering or fabricating physical evidence, a third-degree felony. The court heard the evidence that day, followed a plea agreement, and the court deferred a finding of guilt, did not convict you, and placed you on 3 years of community supervision. The court also assessed a fine of $2,500. It was during that period of your community supervision that the state filed a motion to adjudicate your guilt and revoke your community supervision. It appears that they are alleging 11 separate counts of violations. Have you had enough time to review those violations, those alleged violations with your attorney, Mr. Schmidt?
Yes, sir.
Do you understand everything that you have read and signed in your plea agreement?
Yes, Your Honor.
All right. And are you pleased with Mr. Schmidt as your attorney and the work that he's done?
Yes, Your Honor.
All right. Mr. Schmidt, do you believe Mr. Martinez to be competent? And if so, do you believe that he's entering into this intentionally, knowingly, and voluntarily?
Yes, sir.
I see in the plea agreement that the state's agreeing to abandon counts 5 through 11. Does your client intend to plead true to those remaining counts?
Yes, sir.
And does he waive the formal reading of the state's motion?
Yes, sir.
All right, Mr. Martinez, I see that upon your plea of true today, what you're going to be asking the court to approve is for the court to adjudicate your guilt. That means to convict you of the offense, for your community supervision to be revoked, and your punishment to be assessed under section 1244A of the Texas Penal Code, which is a misdemeanor level punishment at 102 days confinement in the Van Zandt County Jail, with you being ordered to pay the balance of your fees, which include fines, court costs, and reimbursement fees. Is that correct, Mr. Martinez?
Yes, Your Honor.
All right, so at this time, Mr. Martinez, how do you plead to counts 1 through 4, and also, let's see, there were a total of, let's say, 11 counts. All right, so so the only remaining counts are counts 1 through 4. How do you plead to those? Are those counts true or not true?
True. Your Honor.
And you're telling me that those are true because in fact, the violations that have been alleged are true, that you committed those.
Yes, Your Honor.
And Mr. Martinez, has anybody threatened you, forced you, or pressured you to plead true to any of these 4 counts?
No, Your Honor.
Court does accept the defendant's plea of true to counts 1 through 4 as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, the court takes judicial notice of the defendant's judicial confession. The court also admits the evidence, the defendant's waiver of rights, plea of true into evidence. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that Mario Martinez has violated the terms and conditions of his community supervision. Court revokes his community supervision, adjudicates his guilt, convicts him of attempt to commit tampering or fabricating with physical evidence with intent to impair, or assesses punishment under section 1244A at 102 days confinement in the Van Zandt County Jail. Orders him to pay the balance of his financial obligations. Mr. Schmidt, does Mr. Martinez have 102 days credit?
No, sir. He has 12 days credit, so he has 90 days to serve.
Thank you, sir. Court awards Mr. Martinez 12 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Martinez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from the county jail, you need to report to the courthouse to make arrangements to pay your fines, court costs, and fees. Otherwise, a warrant will be issued. Do you understand?
Yes, Your Honor.
All right, step over and be fingerprinted. All right, Mr. Manning, who's next?
Judge, I believe I just have one more client that I've been speaking to probation about, and I think I may have a potential resolution. If I could speak to the prosecution just briefly, we may be able to get Miss Andrea Young resolved. I believe she was just appointed to me.
Okay. Do you want to call the state on your cell phone, or how do you want to do that?
That'd be great, Judge. If we could do that while Mr. Schmidt's getting back over there.
Okay. All right, we're going to stand in recess until Mr. Manning or Mr. Schmidt is ready.
Stephanie will be sending it.
Mr. Manning,
Yes,
taking the plea.
she may withdraw and continue.
We don't.
Hey.
Yes, we're standing up there.
We still gotta go back and do, Richard's person at the. Your Honor.
Yes, ma'am.
Okay, we're ready when you are.
Okay, I don't have a court order, so we're gonna be on ice for.
Okay.
It's still.
All right, Mr. Manning, we're ready. All right, we're on record in cause number CR 22-121, State of Texas versus Andrea Nicole Young. Motion to adjudicate. Go ahead, Mr. Manning.
Yes, Judge, after speaking to the state, we were able to reach, with probation's input and agreement, able to reach an amendment to, resolve this motion. I believe the state is in process of getting that paperwork done. The terms are gonna include that she participate in ISP as a condition of probation, as well as that her back time credit be, eaten up as, part of those conditions. And amend her financials to include $500 for attorney's fees.
And you said probation was supportive?
That is correct, Judge. I spoke to Ms. Burns, and Ms. Burns also spoke to her officer in charge of the case currently.
Ms. Young,
Yes, sir.
are we gonna be, what? You tell me. Why should I allow you to get back on probation, considering the allegations that you're not reporting, that you're testing positive for meth? Why should I give you another chance?
I'm just asking for grace, Your Honor, and mercy, because my grandfather got sick and I relapsed. It had to do with dealing with all of that. I know that I made a wrong decision in doing so, but I just want another second chance, and I hope today that you will grant me that.
I'm gonna consider that, Ms. Young, but you understand that life is full of all kinds of events that could make things hard on us.
Yes,
You
sir.
understand that methamphetamine is not the answer to help you cope.
Yes, sir.
Is this what your grandfather would want? You to be locked up in jail and
No, sir.
having to ask a judge for grace?
No, sir.
I'm sorry that you lost your grandfather, but you're an adult now. There's gonna be, as adults, we're responsible for ourselves and others. There's gonna be a lot of hard times, and you're gonna have to figure out how to cope without methamphetamine, or it is going to ruin your life, destroy your life, or even worse, take your life. You understand that?
Yes, sir.
So I don't know if you've hit rock bottom yet, but if you have, there's really only one way to go, and that's up.
Yes, sir.
And it's not gonna be easy, but I'm willing to give you that opportunity, but
Thank
it can't be a revolving door.
Yes, sir.
Anytime life becomes hard for you, I don't want to hear I had a hard time, so I relapsed. And I understand that relapse is part of the life of an addict. I understand that. And I understand that this is going to be a lifelong addiction, but you're going to have to make that decision on what you want to do, because I'm not going to keep making the decision to put you back on probation. You understand? So now's the time for Andrea to decide what she's going to do with her life, how she's going to react, how she's going to cope, how she's going to deal with stress and tough situations, and whether or not she's going to take the advantage of these offers that she's gotten, not once, but now twice. So, you're going to go to probation and figure out what kind of resources are out there to help you, or are you going to end up back in here and going to prison for up to 10 years? Okay.
Yes, sir.
All right.
Thank you.
The court will state, do you want to add anything?
Nothing really, Your Honor. I agree with the court.
All right, so the agreement is for her to be placed back on community supervision, to be placed on intensive supervision. Whatever back time she's accrued will be ordered by the court as a condition of her community supervision, and she's going to be ordered to pay new attorney fees, reimbursement fees, correct?
That is our understanding, Judge.
All right, Ms. Young, that's what you agree to?
Yes, sir.
Ms. Young, has anybody threatened you, forced you, or pressured you to make that agreement?
No, sir.
All right, Ms. Young, I'm gonna give the ball back to you in your court. All right? It's your
Yes, sir. Thank you.
turn to go dribble it. Don't go out of bounds. You understand?
Yes, sir.
All right. No need to bring Ms. Young back up. Just have the agreement sent to me, and I'll get it signed, and we'll get her processed out back on probation.
Thank you, Judge. I believe that concludes my business. May I be excused?
Yes, sir. We're going to stand in recess until Mr. Fulbright gets here, and then we'll get started immediately. We are on record in cause number CR 22-214, State of Texas versus Cory and Jerrick Fulbright. We're set today on a restitution hearing in this matter. It's my understanding that the parties have reached an agreement with regard to the issue of restitution. Is that correct, Mr. Hernandez?
That is correct, Your Honor.
And the court has prepared an order reflecting that agreement. It appears to be signed by Mr. Hernandez for the state, Mr. Schmidt. You and your client have reviewed it. Y'all agreed to it and y'all signed this order. Is that correct? Yes, that's correct. All right, then based on the agreement, the court will follow the agreement. Court hereby orders Cory and Jerrick Fulbright to pay restitution in the amount of $35,000 to Mr. Jerry Red at the address located in the court's agreed order on restitution. We have anything else in this matter?
Yes, Your Honor. Mr. Red is present in the courtroom and would like an opportunity for allocution here.
Mr. Schmidt, any objection? Okay. All right, you can come forward.
Thank you, Your Honor.
Sure. Yes, no, it's good. Just look on there. Look on there and hit the start. That video, see down in the lower right where it says start. Go ahead, sir. You proceed whenever you want.
Okay. Thank you very much. Thank you for the time. My name is Jerry Red. I just want to take a minute to address the defendant who I've known for a long time. Just got a prepared statement to read to you, Zakorian. And basically it says, Mr. Fulbright, I've known you now for several years, since you were in high school. I still remember contacting the then high school coach, football coach at Wills Point to see if he would recommend any of his players to work for me for extra money part-time. Without hesitation, he gave me your name and I think one other. Back then, I was in my 60s, and you were either a sophomore or a junior, I'm not sure. You were playing football. And I'm 74 now, had open heart surgery, had a lot of changes in my life and everything. But you worked for me for several years, Zakorian. And I'll be honest, you're one of the hardest workers I'd ever had. No one ever worked harder than you did. I trusted you, me and my wife, Debbie, who's sitting out there. We trusted you with everything. We trust you like a son. I have 3 sons and another stepson, stepdaughter. And I trust you. We'd leave the house, leave you there working, you know, whatever. And just, I had no problem with you staying there. I paid you extra money sometimes from what I agreed to. And I'd buy you a meal or 2 every now and then when you were hungry. You went through some tough times, and I tried to help you. When you were down on your luck, Debbie and I discussed it. And we even offered you one of our bedrooms to stay at, so you can have a place to stay. And you turned us down, you thanked us. And it was actually, ironically, about that same time, I think it was that weekend after I went back to cameras, was the same weekend that I offered you a place to stay that you broke into my building. And I have you on camera, which they have all that information. You know, I watched you, Zakorian, on my cameras. I watched you get out of the car in my driveway. And I watched you make several trips down the side of the building. And you had to go in, the only place to go in, there was no door in the back, was a doggy door. That was the only way you could get in because the other doors never opened. Over the next almost 1 hour, you loaded many of my coin albums. I had them in 3-ring binders. I had an entire cabinet full back there that when I saw it later was empty, okay, for the most part. A few scattered were still there. But you loaded coin albums that I'd collected my entire life. Most of the coins were silver, but it included other kinds of coins, foreign coins, paper money, and so on. You made several trips to the passenger side of your car where you're visible on camera, loading the albums into the passenger side of the car. And when you were arrested, the officers found about 30 loose coins in your car. So you stole items of mine that were monetarily valuable. We're not rich people. Debbie and I are semi-retired. I'm still working a little bit, but we're semi-retired. And the coins were worth a lot of money, not only to me and my wife, but you know what, Zagorin? They were worth something to my 5 children, my 17 great-grandchildren, my 5 great-grandchildren. So they're all sitting up here with me, okay? What you called stole from me, another word that begins with the letter M, just like money. That was called memories. The memory of me riding with my grandparents when I was 6 years old to the bank. He'd go in the bank through the drive-thru in our little 1950 Chevrolet truck with no heater, air conditioner, no radio, no nothing. And he'd pick up $20 worth of rolled coins. And I was 6, 7 years old. We did this for years. He'd give them to me. I'd get home. I'd spread them out on the floor. And I'd put them in my little blue Whitten books by date. Not knowing all the others that I rolled back and gave to him to give back. I wish I'd kept, because a lot of them were silver. Yeah, but I rolled them back and gave them back. But anyhow, he did $20 worth every payday out of his meager check. And then I'd give him back probably $15, $17 because I didn't need the others. That's how I started collecting almost 70 years ago. I'm 74 now. I stayed enchanted with my coin collecting my entire life. I purchased coins in various places, and I amassed a large collection. You took a large part of that silver collection, which was really my pride and joy. I had binders of Barber Morgan's, Barber coins, Morgan and Peace dollars, $50, quarters, and all the other silver $50, including Liberties. I know every coin there is out there. I know every error coin there is. You stole my prize Kennedy collection of everything. And it wasn't worth but a few $1,000s by itself. But that was one of my prizes because it was complete. I've since started trying to replace some of the coins, paper money, but it took me almost 70 years to get there, and I'll never replace them all. But you know what? That's not going to matter. It's not going to matter when I'm not here someday. It's going to matter to my kids and grandkids and great-grandkids. See, you may not know it. I don't know if I ever talked to you or not, but I was an old coach for 16 years. I coached hundreds of young boys and girls, and I prided myself in not only teaching them the sport, for which the most part was baseball and soccer, but I tried to teach them about life. In particular, I would stress that all choices have consequences, some good and some bad. Out of all those years of coaching, I was blessed to have a lot of good things happen as far as these young men and women receiving scholarships, playing pro sports, having successful business careers, families, and I still keep up with them. You know, they're in their 50s now. I only had one loss during that time. When I say a loss, of one young man I tried to save as a young man from 8, 9, 10 years old, and I didn't make it. And he's still incarcerated today. You're the second one that I can't say the word lost, but I'm disappointed in because I was close with you. Okay? I want you to know something. I'm not bitter. No, I was mad when I first saw that empty cabinet and went back on the camera, and I went back a week. It took me a week to find you pulling in my driveway. And when you got out of that car, there was anger. There was, I can't even, every emotion there can be. I said, not Z. I went and told Debbie. I said, Debbie, it was Z that stole the coins. She went, no, it couldn't be. But it was. But if I could go back in time before you had trouble with the law, and I could get your record totally wiped clean and counsel you some way, I'd gladly give the value of all those coins up. So I can tell you from my heart that I wish you nothing but the best from here on out. I pray you get your life turned around. Start hanging with the right people, which is the key to getting your life turned around. Start reading the Bible daily. God bless you. Thank you for your time.
Thank you, Mr. Red.
Thank you.
Anything further, Mr. Hernandez? Mr. Hartwell?
No, Your Honor. Thank you
All right.
very much.
All right, then that adjourns this matter, and that does finalize the court's criminal docket. We adjourn for the day.